We're not going to be talking about surveillance as much. I think we'll focus mostly on privacy issues and free expression issues as the primary topics. So I'm going to just allow my panelists to introduce themselves at the lengths to which they feel they would like to.
I don't usually like to go at great length. Hi, I'm Michelle Demoy with Consumer Action. I work with Consumer Action as an advocate for digital privacy. And Consumer Action, in case you've never heard of us, is a 44-year-old national nonprofit with offices in San Francisco, Los Angeles, and in DC. And in DC, we advocate for sort of a whole host of consumer issues. Privacy is one of them, housing, insurance, credit cards, sort of pocketbook issues. And then the last couple of years, my work has started to revolve, I would say, a lot around health privacy, social media privacy, workplace data privacy, and coincidentally, this is also the case in the States, so I'll be talking about that.
And I'm Rob Sherman. I work at Facebook. I'm the Deputy Chief Privacy Officer there. A lot of my work is with the product teams that are building Facebook to make sure that we're thinking about privacy as we're building the products and services that people use on our website and our mobile app every day. And in addition to that, I work with a lot of the folks in this room and also policymakers from around the world and in each of the states on building policies for privacy and internet policy that are really sensible and promote privacy and innovation at the same time. So I think it's a really interesting topic, one that we this group of us, but a lot of us in the room have spent a lot of time thinking about, and I think a really timely thing given the attention that the states are paying to privacy these days.
Great. So I'm going to sort of give a brief introduction to this topic because I know that it may seem quite broad and there's some sort of interesting constitutional legal questions that maybe not everyone has had a lot of exposure to. So what has prompted this interest, as Rob and Michelle mentioned, is that we traditionally think about the federal government passing the laws that affect nationwide commercial issues. We see this in copyright and patent. Privacy and national security, the federal government plays a major role. States, historically perhaps were not thought to have act outside their jurisdiction, outside their physical boundaries. And so, states deal with licensures, states deal with police, local education, things like that. In the internet age, when borders are more porous, you can have a state passing a law that has effects well outside the boundaries of that state. And this is sort of becoming an interesting area in that you may have states have conflicting obligations or requirements for companies, whether it has to do with notification for a data breach, the ability to delete data if, from a social media site. Sometimes, with Margot's work on drones sort of looks at how drone operators can operate on a state-by-state level, even though we often think of air travel as being regulated by the Federal Aviation Administration. These are the sorts of topics that increasingly are being, the states are paying attention to. The sort of legal constitutional issue here is, sort of federalism or preemption. Basically, because the federal government has limited powers, all powers not reserved to the federal government are left to the states. But if the federal government does have the ability to legislate, oftentimes its laws will supersede or preempt state laws. This is sort of complicated and a case-by-case issue that I'm not going to get much into, especially because it's been years since I took constitutional law. But all that means is that sometimes federal law and state law are inconsistent, and that can lead to problems with implementation or with legality, which create a whole host of issues, on the ground. The only other thing I will say is that there's a narrative that's very popular and I think probably pretty accurate, although I don't know how you measure it, is that the federal Congress can't do anything. Whether or not this is true, what it means is that states, I think, are seen as an interesting place for legislation on internet policy and technology issues to get done. Yesterday at a panel that Chris Calabrese of the ACLU moderated on civil rights and big data, there was a question about whether or not states are a good forum for that. And I think the panelists expressed some interest in that idea, but also pointed out that there can be some shortcomings as well. And I think we'll explore that as well here. But I did want to set the stage just to sort of talk about what sorts of issues rise in how this topic is becoming more interesting, or at least more prevalent, as we see state legislatures and, in some cases, administrative agencies increasingly involved in regulating and legislating on these issues. So I'm going to turn it over to Michelle to sort of talk about maybe some on-the-ground examples.
Sure. Sure, I'm happy to. We think that the states have become probably the most effective weapon in the arsenal of privacy advocates. And that, it's a messy weapon. It's got some issues, and we can go into that later. But I think it's important because they're tackling some of the most difficult privacy issues that we're facing, and probably the most impactful as far as consumers are concerned. And at Consumer Action, our constituents are underserved and disadvantaged communities. So civil rights big data conversation is something I take very seriously, and it's always a lens that I'm putting on the work that I'm doing. Here's a great example. In New Hampshire this year, I thought this was kind of important. New Hampshire, of course, already has some really great, strict data privacy laws, but they amended a student data privacy law to make it even stronger. But what's interesting about it is that, as they did that, they kind of made a connection between the database that they have and the type of information that they have in it. In other words, that some of the information, such as whether a poor student does better on a test or a rich student, and that comparative analysis, that is important. I think that's a pretty crucial, I don't know if it's a precedent, but it's a crucial thing that the legislature did, because they connected the dots on data and said, now this data and this data together become something that's even more important and more in need of privacy protection. Another interesting law, Maine has a social media in the workplace law. So I touched on the fact that social media and workplace are becoming big issues. And sometimes in some states it's just social media. Sometimes they're connected with other things, such as not prohibiting discrimination based on social media data. Again, when you put the lens of an underserved community and you have things like insurance rates and mortgage rates and jobs, the impact of sort of a discriminatory practice based on social media becomes much greater and more important to protect. But in this case, Maine says if an employer requires an employee to disclose their login information, the employer may be subject to a private civil action in which the affected employee may recover 3 times any wages the employee has lost, civil damages up to $1,000, and attorney's fees. That's important. I think probably everybody in here knows that, but the fact that there is a right of private action, and that's another reason I wanted to bring up Maine's law, because that's often the case in states, whereas of course in federal, particularly in privacy laws, that's almost never the case. So these are important. Another one I thought was interesting was there's a new law in Colorado that limits the State Department of Revenue's ability to audit personal medical information, and this was actually born out of taxing of cosmetic medical procedures such as Botox injections. So more and more people are starting to understand and connect the dots between those sort of important issues that are coming together, the health privacy of it, where the data lives, the financial ramifications of that, and the medical ramifications of that. So that was another interesting one. And of course, there's California's eraser bill, which happily will be going into effect January 1st of next year. And this will make California the first state in the country to require select operators to allow minors to either personally remove or request and obtain removal of online content they've posted. It also has restrictions on advertising and marketing to specific categories of age-restricted products. And so it's a very specific law, which is good and bad. It misses some things, but it hits a lot of really key privacy issues, particularly when it comes to minors. So this bill was carefully crafted. It was torn apart a little bit. And if you know anything about California law, it's incredibly, insane, the way that their system works. We have somebody in California who works on California law, privacy law, and just even listening to him explain sometimes the process of how a bill has gone through or not gone through gives me a headache. But anyway, I'll cede the floor. So those are some of the newer kind of state laws that have come into effect.
Great, thanks. It's very helpful, and having on-the-ground examples, I think, makes this a more concrete discussion rather than sort of talking about federalism, which is a bit in the air. I will let Rob talk a little bit about the sort of perspective from business about how to sort of deal with compliance or understanding what's going on when. Oftentimes these bills come up very fast and not without a notice, unlike in the federal system when I think we have on more occasions we have some more advance notice. So I'll let Rob talk about those issues.
Sure. So I come at these issues from two perspectives that are similar but different. And so the first of these is I work on Facebook to help keep people's information protected and keep people's information secure. So for example, we rely on state law when we go after people that are trying to gain access on an unauthorized basis to information on Facebook. And so state law can be a really useful tool in that context. I'm also one of the people that's responsible for implementing laws that we're subject to. And so I think about laws not only from the perspective of how we can use them to help protect privacy, but also how can we implement them, and is it feasible for us to implement them, and do we know what the law's trying to make us do? And so very often those things coexist happily. Sometimes in state law they don't. And so I think that's one of the issues that I think we'll talk about on this panel. So what are some areas? So Gautam, you raised. What are some areas where state law can be really successful and effective?
I think the data breach example is one where we often cite as being beneficial, although I know that there often are compliance costs. So what this means, for those who are maybe not up on this issue, is that I think it's 47. It's close to all the states have passed a data breach bill of some sort. These vary, right? So some of them may be notifications, some of them might be certain standards, some of them are identical to each other. So it's quite what we refer to as a patchwork of legislation. There's no federal data breach law at the moment. But in the wake of recent high-profile data breaches, which I think many of you have read about from late last year and earlier this year, there were many, many hearings held in Congress earlier this year about the possibility of federal data breach law, data security, the FTC's role. I think Chairwoman Edith Ramirez of the FTC testified like 5 times, probably saying the same thing every time, but there's not much to say, right? You can say that the FTC should regulate data security. You can say there should be a federal data breach law. The issue that I think consumer advocates like myself and Michelle have, I don't want to speak for you, but at least for us, one of the issues we have about this is a federal law might be helpful, but when you have a company that operates in every state, and the laws have varying levels of compliance, the company, probably to be safe, will comply with the most stringent law. A federal law probably would not reach that level. And so there's the possibility that through passing federal legislation that would preempt state law, that you would actually weaken the consumer protections. Now, I think this is a bit of an abstract debate until there's an actual bill that comes to the floor that we see movement on, and that has not happened yet. But that is sort of one of the trade-offs that you get, is when you have states acting in this way. Sometimes it can be more beneficial, but then compliance costs can be also very high, and so then cost of service can go up. There's a lot of different moving parts in this debate, and I think there are ways to solve them. But I think that's one of those where you can sort of see both the effect on the companies in terms of compliance and understanding what the laws do, and also this interesting interplay between the federal and the state legislatures.
Yeah, so it's maybe worth taking a step back, and I agree with you that data breach legislation is a good example, and I think it's a helpful place where states have moved the ball forward in a very demonstrable way around privacy. I mean, I'd be interested in your thoughts about what is good about that legislation and what is bad, because I think we can go down. There are lots of examples. I think Michelle gave some good ones about how this legislation works. And I mean, I think the one thing, I sort of was thinking about data breach as a class. I mean, one thing that category of law does well is that it's targeted to a clear harm, right? So we know people have information that's private, it's made public. People can be subject in cases where the wrong information is made public, they can be subject to identity theft, those kinds of things. And there are clear things that we know are harms. There's a clear nexus to the states in the sense that we know that there's a person whose information gets out in that place. The harm, if it's going to happen to them, is going to happen there. The good data breach notification laws are technology neutral, right? They don't say, well, if you use this particular kind of server and the information gets out, then you're liable, but if you use that kind of server, you're not liable. These laws are focused on the existence of the information, however it's stored, and they typically will say if you don't protect them adequately, then you're going to be liable to these notification obligations. And if you do protect it adequately, so if encrypted information gets out, then typically that's excluded because somebody gets a copy of encrypted information. If it's reasonably well encrypted, those consequences aren't going to happen. I mean, I think the place where I think there potentially are compliance challenges is and this comes up in data breach notification law. I mean, you talked about California law as well. This is another place where sometimes these issues get raised. It creates a situation where there's either a difficulty of complying across states for a company like Facebook, where we're a global company, and so obviously our imperative is to do the right thing, not just in one particular jurisdiction, but for everybody who uses Facebook. And so that means we have to think a lot about what's the right thing to do across lots of jurisdictions. And if we have to run a fundamentally different service, then that becomes difficult. Now, I think you identified what I think most companies do in the area of data breach notification legislation now, which is they figure out what the baseline requirement is and comply with all of that. Now that works in most cases, but I think you still get to a situation I mean, sometimes you see proposals, and thankfully these haven't become law, where they say the notification has to be in this type of font or has to use this magic language. And so we kind of laugh about that and say, well, that's a silly proposal, but you actually do see these proposals quite frequently where states want they want to be clear that they're protecting their citizens, and so they have specific requirements. And I think when you digest it away from sort of a substantive requirement that says you have to let people know if their data gets lost, if there's a risk of harm to them, and obviously there's a lot more detail below that surface, to, well, you have to use this color ink and this specific magic language, that becomes a lot harder to administer. And I think the value of compliance with those kinds of requirements goes down relative to the substantive ones.
I think one thing that's worth noting is that, a lot of states, not a lot, but some states have a constitutional right to privacy. And, so when they're looking at harms, that's important. And the data breach laws, again, I agree, are much easier in a way to write and to implement. But they're also looking to protect that right of privacy, however it's written. And the states all have different ways of writing it and different lengths of specificity. But I think that's kind of an important note, too, that it's not just about the harm, but it's about protecting that right a lot of times.
Yeah, and I think, Michelle's point emphasizes that part of the reason, or at least I was told this in constitutional law, that we have the federal system is that, states are perhaps better suited to administer certain concerns or interests of their citizens. And if a constitutional right is enshrined within a state's constitution, then you can understand why the state legislature would want to sort of not just let that sit as part of some old document, but try to actualize it to some extent. I think Rob's point that some of the ways in which they do that can be more effective than others, and certain requirements are not really necessarily following through on what we might think a state's interest or purported interest should be. I think that does raise a question that I'm sort of wondering if you both have thoughts on, or if it touches on some of the things we've discussed already, is to, the kinds of interests, whatever that means. It can be a privacy interest, it could be sort of a regulatory interest, if we want to be more broad, that a state is perhaps particularly well suited to address through legislation in this area.
I don't have a really specific answer to that. I mean, unless precedent makes the state well suited. California is a great example. They pretty much every year pass privacy laws, and they have sort of some expertise in the state legislature that gives them an edge in writing some of these bills, technological expertise or legal expertise, and also precedents, so that you can build upon something that is technology neutral, and they're not just sort of constantly responding to the latest trend online. I think they've done a fairly good job of that. I think Texas has a strong history in health privacy, and I think that their precedent, those laws help the state to write really kind of more future-looking type laws. Actually, I was just looking at one, but that's not health privacy. But they tend to take a broad view, and they give their consumers in their state a lot of protections when it comes to health privacy. So they're kind of well-suited that way. Other than that, I can't really think of particular ways in which a state would be more suited to writing.
Yeah, well, I guess like one thing that I've been thinking about lately is sort of what makes a state want to take on a specific technology policy issue when, it's one thing to say, in Ohio we want our roads to be a certain width, right? I mean, it's a road in Ohio, that makes sense. You'd be concerned about that. But I'm starting to, I wonder if, things like, you mentioned the eraser button bill, cyberbullying, revenge porn, drones, these are things that get a lot of news attention. And I think a theory that I, haven't really fully baked yet, but I'm curious about is whether these kinds of like high impact media stories plus the perceived absence of federal intervention means that state legislators even feel like, oh, this is a way for me to do something about it and perhaps get some PR, or this is something where constituents are like, what are you doing about this? This is a problem. Schools and kids, oh my God. And I wonder if that has some component to why this might be, these issues in particular might be on the rise.
So I guess I'm not the right person to say why state legislatures do or don't take up certain issues, but I think the revenge porn, right? So this is what we're colloquially calling it, but it's unauthorized distribution of intimate images. So this has been something that's been, so this isn't something that has been a significant focus of attention in state legislatures. I think Colorado just passed a bill. Maryland has a bill on this. Yeah. And I would argue this is a good place for state legislatures to be spending their time. First of all, wearing my hat not as implementer, but as somebody who's responsible for protecting the privacy of the people who use our service, it's an important issue, and I think it's one, importantly, and this is one reason why I think it's an appropriate issue for state legislatures to take up. Very often the bullying that the negative consequences that arise from revenge porn and the bullying that occurs, those start and end offline, those start and end in communities and schools. And this isn't the kind of thing where the FTC can pass, where Congress can pass a law, or the FTC can adopt rules that say, okay, well, here's how we're going to solve this problem. I think the FTC just isn't well positioned to go looking at revenge porn cases. It's not. And I think I don't want to speak for the FTC, but I suspect they would have the same view. It is a thing that with a fundamental nexus to a community, and whether this stuff happens online or offline or in a combination of those situations, it's important for there to be guidelines that say it's not okay for us to do this. I think the same principles that we've been talking about apply here, right? So it's not distribution of intimate images, whether you do it on Facebook or Google or Twitter or on a bulletin board in a school, that doesn't matter so much. What matters is the publication. I think when those laws are done well, they also are targeted, like most state laws are, to specific harms. The one in this case is pretty obvious. There's a significant emotional injury and potentially something more serious. And also states are better positioned to look at the intent of the person that's engaged in this conduct and understand is this an advocate violence against women advocacy group that's trying to raise awareness, or is this a bully who's trying to harass somebody? And again, federal law is and our federal law enforcement structure isn't as well positioned to do that. Now, again, I think you contrast that to, generalized rules about how websites or how companies should handle privacy disclosures and what should you say to people. I think you get into, this famous Supreme Court case, Bibb versus Navajo Freight Lines, which talked about mud flaps. So I think it was Illinois had rules that the mud flaps had to be curved, and the adjoining states had rules that the mud flaps had to be rectangular. There was no real public safety reason for this. It was just that they didn't want as many trucks on their road. And so, I think you get into those situations. You could imagine a case where, to go back to my earlier example, where, different states say, okay, your privacy policy has to be this color, or it has to, have the name of our state in the link, or these things. And, those are things that I think get difficult to
Can I just say
to
something?
implement.
I
Sure.
think I actually disagree with you about the platform not sort of being associated with the bullying, in the sense that it happens offline mostly. Because I think when you have a platform like Facebook, you exponentially expand the ability of the bullier or the group to harm the victim, right? In other words, you give a mechanism for much greater harm in terms of public harm, humiliation, etc. So I think there's that, right? And especially when you have so many users, there's a certain responsibility. And I think also almost all bullying, at least as far as I understand it, is mostly around schools, right? So I think Facebook and other companies like that do bear some responsibility when they're marketing to not necessarily just minors, but schools. When you have school groups and the monitoring of that, I think the FTC could find a way to monitor sort of that out of the fact that it's a company that's sort of marketing to a school, and the school has users that may be like groups that are a part of the school functions, etc. So I mean, I think there might possibly be a way for that. And I just think that it's easy to say that this is all something that happens outside, but you have to understand, I mean, I think you do understand this, but the online tools that are sort of almost anonymous. In other words, you have groups on Facebook that are, I hate so-and-so. And I know that Facebook monitors some of that, but I think that's where there's been too much of a hands-off approach from companies, and states feel like they need to step in. But if you think about it, I think actually a broader FTC type look at something like that would be more effective and probably more impactful than some state legislature that sort of writes something that's very narrow, and possibly technology sort of gets it wrong.
So I should correct something if I misspoke. I absolutely think that companies like mine have a role to play here, and I think it's important. We have thousands of people who are working around the globe on this issue, on making sure that we're looking at the content that we manage, and making sure that when people report things to Facebook, that it's looked at expeditiously, and that we are being responsible with the people that communicate on our platform. So absolutely, we have a role to play, and I think we're working. It's one of the most pressing issues that we have in terms of making sure that we have a safe and responsible place. I think you talked about anonymity. I mean, real name culture is another thing that plays into that on Facebook.
Right.
You have to use your real name when you communicate, and I think that builds accountability that you don't necessarily have in a place where there's anonymity. But what I meant to say was not that we're not responsible, and if I said that, then I misspoke. What I meant was, this isn't a problem that any particular platform can solve by itself, or any particular stakeholder can solve by itself, right? Even, so somebody gave an example recently of, a picture of a dog that was posted, and it was just a dog, right? And, somebody reported it to Facebook, and we didn't take the content down because it was just a dog and we didn't have any context. It turns out that this was part of a bullying that was going on, and so once we found out about it, then we were able to take action. The problem is Facebook doesn't have context for a lot of that stuff, and so so you're right that people do use Facebook to amplify their message, and that's one reason why we have to take responsibility and be really active in building those kinds of discussions. But at the same time, we're not best positioned to know why that dog picture is objectionable. We're not, and and people who whether it's authority figure, parents or authority figures in those communities, are often better positioned, or law enforcement agencies in those communities are often better positioned to know when something is a concern and take action. That's not to say that we don't have a role, but I think it's one where there has to be a broad conversation. And the reason why I say that, I think it's appropriate and helpful for state and local authorities to be involved in this is because, without that, there's almost invariably, although not exclusively, a local connection, and the bad thing that happens at the end, whatever it is, typically doesn't happen online, and we don't have context for what that is. And so I think we have as a community a responsibility to do that. So I didn't mean to say that platforms don't have any role here, but just that it's a broader issue.
Rob, that sort of touches on a point that I think is really a question of resources, and that you probably are not going to place a sort of Facebook warden in every school, and no platform can do that. And relatedly, Michelle, I know that you don't have infinite staff working on with you to monitor all the legislation that's going on, much as we might want infinite staff that we don't have to pay, maybe interns. No, we also pay our interns. I am wondering though, most of us, and even in a large company, I suppose you could, I think this is one of the points that was raised on the earlier panel on the right to be forgotten, that, implementation is hard when you have limited resources. So to that end, how do we, both, business, NGO, and even federal regulatory, maybe in some cases, how do we keep track of these bills? There's not a Thomas for every state necessarily, or may not be easy to use, and there's not a lobbyist in every state necessarily either. So is it a triage mentality? Is it a, sort of keep an eye out, wait for someone to, I've had reporters call and be like, oh, did you hear about this bill? And we're like, no, we should go look that up. And, how do we sort of get a handle of this phenomenon?
I can tell you that happens to me a lot. And, it's always some sort of just really obscure bill that, I know nothing about, and then I'll get some quote in some paper somewhere where I sound like a complete moron, because they always choose the least interesting thing that I say about it. I think one of the answers to that question is outreach, and that's sort of difficult because, of course, you're talking about capacity of NGOs, et cetera. I'm the person, I'm it for digital privacy. But when I've sort of put myself out there a couple years in a row to go to different places to do advocacy directly to some of the people, for example, in state assemblies or to school boards. This was an interesting conversation I had recently with somebody from Massachusetts. They're looking at some education privacy laws, and what he said to me was, really, and sort of, it wasn't confidential, but he was saying it kind of separately from everybody else's. I think we just need some best practices to give these schools, because a lot of the schools, just have no clue. And, so I'm thinking about it, and I said, well, you can try the ACLU, you can try Future Privacy Forum, they have some information about this. But really, there's so little to guide schools, which is kind of insane. So part of what I think is that we take a step back from the legislation at times, depending on what the issue is, and look at things like, sort of the nuts and bolts of the people who are affected by this. And schools are a great example of, and this would be one way to kind of educate the schools about bullying online. I think there's a lot of resources now about bullying, but just sort of the other stuff. He said, one way that we're going to address the social media issue is that we're going to hand out our own devices, and the kids have specific rules on their own devices, and coaches and teachers aren't allowed to access student social media profiles. And I said, well, can't they just go home and access it? And he said, well, yes, and that's sort of something we're working out. So I think that, it's like that kind of stuff is where, when you have somebody to talk to about it, somebody outside, when you get outside the DC bubble, you learn a lot more about what people are actually worried about. The state legislatures, I tend to kind of lose interest after a while watching the political battles, because a lot of it is just somebody trying to make a name for themselves. The bill will come up, go down. Sometimes that's not the case, but many times it is, and it is a very popular subject, especially in states where the privacy is sort of a long-held belief, like New Hampshire. I think when you're looking at resources too, that also has to include outreach to developers and engineers and to the vendors. So that's sort of an area that I think a lot of times is overlooked. It goes to best practices, but it also goes to, you talk to the people who are creating these products that the state legislatures are then going to regulate in some way. And I found that to be really effective, especially because you're baking it in from the start, but it's not just the software components, it's the conversation that you have with the vendors. It's the sort of framing and understanding of where the consumers are on this, where the states are on this, so that you don't get into the huge battle that really wastes everybody's time. So that's one way that I would look at that.
Yeah, I think that makes a lot of sense. I mean, we talked about sort of the difference between the federal process and the state process. I mean, one feature of the state process is that things can happen a lot quicker. I think, as we were preparing for this panel, I think one thing that we all agreed on was that, at the federal level, when there's legislation, it may be that legislation moves more slowly, but everybody who wants to have a voice has at least had an opportunity to have their voice heard and make their pitch for what they think is the right outcome. It's not always true in the states, just because many of our organizations are resource constrained. Certainly NGOs are. I mean, at Facebook, even though we have more people than Consumer Action or CDT on our staff, most of those people are working on engaging with the communities that we serve, looking at content or engineering. I mean, those are sort of the bulk of the staff that we have. And so we don't have a huge staff looking at state legislation and figuring out, okay, let's have a person in every state. I mean, we don't have the resources for that either. And so I think one possible solution is that we as a community need to do better about working together to have these conversations about what's going on, and to your point, Michelle, have best practices about what's a good way to address a particular problem and what's not a good way. And I think we've started to talk about those, but I don't think we've built out that infrastructure in a way that is as sustainable as it could be. I mean, I know that Ryan Kalo at the University of Washington, for example, has a center, and it's not partisan, not expressing any particular view, but just working to make available to policymakers better information about how technology works. And I think, a lot of the issues that, some people raise with certain pieces of state legislation, if we make available information about how technology works and, what are best practices, I think that can help a lot with, each of our various interests. We may end up not agreeing on exactly how a particular piece of legislation should end up at the end of the day, but I think collaborating on actually understanding what's going on and providing resources to policymakers across the states is a really good use of our resources.
Yeah, I actually somewhat boringly agree that we have a lot of educating to do, and it increasingly is not going to be inside the Beltway. I think the good thing about the sort of pervasiveness of technology in a variety of forms, whether it's smartphone, tablet, wearable, computer, whatever, home device, car, the list goes on, means that the increasing ways in which technology implicates our lives mean that there's going to be a lot of not just sort of policy thinking and best practices, but communicating. And I think those of us who have been in this field for a few years have really assimilated the data, no pun intended, about how these things work and what the implications are. But for better or for worse, unlike many other sort of typical legal regulatory issues, it's just not, I think, as historical a topic for people to think about.
And I just want to add on that, the communication part, as an advocate, that's huge. And a big part of my job is to try to reach out to regular people and find out what they think, what they want me to talk about, and also get them harnessed. So one of the great things I think about some of these laws is kind of raising to the surface some of the practices, right? I mean, in California, the tracking information that people will now get, it's great that they're doing it, but for me, the major benefit is that people will see this, hopefully. They may not take action. I think sort of Google, with their Gmail encryption, I think maybe betting that people really won't take action. But I do think that that's helpful, and part of the reason that's helpful is that when I send communications to grassroots networks, they're a little more engaged. Consumer Action has a national consumer empowerment conference where we have a network of community organizations that's about 8,000. And so we bring some of our best, and they work on all kinds of issues with disadvantaged populations. And I talk about privacy in the pocketbook way. I try to constantly connect it to how it's affecting or not, how it's affecting people's lives. And that conversation's getting easier. The questions are getting more astute. The questions are getting more specific. And I think that's due to a lot of reasons, the media. But I think it's also that when we're able to communicate about something local, we're able to say, this is happening in your jurisdiction, this is happening, this is what's going on, this is what's holding up something that would really protect you. People are much more responsive, so it then becomes my job to be more local about my message.
I'm going to ask one more question and then give time for anyone here to ask questions as well. And that is sort of, you opened up talking about the eraser button bill that California has passed. And, in the sort of federalism context, you can see ways in which laws at the state level can be overturned if they're challenged. I think, the eraser button concept is one that has raised a lot of First Amendment issues and questions. The sort of scope of the bill, how a specific bill is written can make a big difference as to whether or not it survives that level of scrutiny. Now, of course, a law is a law until it isn't, and someone would have to take it to court and, eventually have it perhaps be litigated for many years. And the question I sort of am wondering is that something that we think might see happen going forward? Will there be some plaintiffs in the eraser button context or in other ways in which federal, constitutional, or other regulatory regimes would override a state law? Do we think that there are going to be plaintiffs or any sort of action to try to get these laws overturned through that kind of way? Or would it be better to sort of think about going to the state legislator and saying, well, maybe this is another way to do this, and maybe you should revise or reform your law, or both?
So I don't know if there's going to be if there's going to be litigation. I mean, I think my sense is that historically litigation has been less tactical and more responsive to, a particular law is enforced against a particular entity in a case, and then their argument is that it's unconstitutional for a certain reason. So I suspect we're not going to see a lot of litigation advocacy where people are bringing strategic suits to try to take down this legislation. But I do think over time, as they're enforced, whoever is on the defending side of those will start to raise those arguments. I mean, and I think we've talked about a lot of them. I mean, there's this is a computers freedom and privacy conference, and so we think about privacy here, but we also think about freedom of speech and freedom of association and those sorts of things. And I think when you look at something like at the federal level, Section 230 of the Communications Act, which says that service providers aren't responsible for what people do on their platforms. That's a thing that I think at some point is going to be litigated, right? So we're going to have to, where you have laws, and I think, we haven't seen any that are particularly egregious, but you can imagine laws that start to say, like, you can't engage in this kind of speech online, right? So, and there could be very legitimate reasons for doing that. But we as a community, I think, have to balance, the need to the interest in preserving whatever the interest is we're trying to preserve against the interest in squelching speech, either directly or by imposing this kind of collateral liability that Section 230 seeks to address. I don't know where that's going to come up, but I think this is an issue that obviously people think about a lot. I think the preemption and dormant commerce clause kinds of issues that we've talked about also are going to continue to be an issue, but I think, my guess is we see more legislation before we see more litigation.
Okay, well, I want to make sure people have time for questions if they have any. I thought that might
I
happen.
guess we were very comprehensive, maybe.
I hope so.
Just incredibly boring.
Well, I will give both of you, if you have any final thoughts or things you want to share on this topic. I know it's a broad one, but I think one that we're seeing a lot of attention being given.
Sure. I guess my final thoughts are that, again, for me, advocacy started sort of up here in privacy, and in the last 7 years almost at Consumer Action. It's interestingly changed to go a little more detailed. In other words, I started out going to a lot of meetings and talking about a lot of sort of technical things and policy that's way up here, and to the point, and now where I'm down to, calling different people in different states and community groups and saying, what have you heard about this practice? What's the community talking about in terms of privacy? And then also talking to people who man our national hotline. That's actually become a great source of information for me. Not only just on what consumers are saying, but the problems that they're having. It's one thing to talk to the FTC about the sort of problems, privacy-related problems that people have, and it's another thing to hear it from them. And of course, some of the issues are the populations themselves. So senior populations, for example, it's a huge issue. It's a really big issue. They've done a bunch of surveys, and seniors are more and more online. They have devices, et cetera. Also, disadvantaged communities are rapidly, devices are pretty much the only thing that they use. This is true all over the place, but again, the privacy impact of that is different for somebody who has a lot more to lose when they have a lot less. So I think state legislatures are right to take up a lot of these issues. They're right to look at them the way that, for example, New Hampshire did by connecting not just data privacy as a whole, but data analysis and the way in which predictive data impacts sort of regular consumers.
So I think a lot of what we've talked about today is the process of the global becoming local. And I think we've seen an evolution in the approach that state legislatures are taking to these issues. And I think it's important that, that states consider them, and that we as people who think about these things at a national and global level are also focused on them. But I think, initially the first phase of what you saw was a lot of legislation that largely tried to mirror federal legislation and capture it but tweak it in one way or another. And I think then we saw the pendulum swing back, and I think what we're going to see going forward, what I hope we're going to see forward, is states really carving out a niche for themselves that's different from trying to sort of do what the FTC does better, but actually focused on, what are some ways that they can protect their citizens and do it in a sensible way that is tailored to the areas where states have strength. So I think, to bring in the other thing that we just talked about, I think, we as a community have more work to do to thinking about what are the right ways for that to happen and how we can work together to create sensible policy at the state level.
Mm-hmm, mm-hmm.
Great. Well, I urge all of you to continue to read local papers and to see what new bills come up, as I think that many of them will be quite interesting and raise some of the issues we've discussed today. And thank you also to Amy and to Nuala and to the CFP staff for having us, and thank you for attending.